Thank you, Your Honor, and may it please the Court. My name is Greg Cunningham, and I represent Defendant PepsiCo in the matter brought forth by Messrs. Joyce and Voigt. Your Honor, the Court should set aside its default judgment pursuant to Federal Rules of Civil Procedure Rule 60B1. This would be in the furtherance of justice and allow the Court to evaluate this case on the merits. Looking to the text of 60B1, the Court may provide relief to PepsiCo upon demonstration that its default was owing to either mistake, inadvertence, surprise, or excusable neglect. And based on prior court holdings, this rule should obtain here, provided, first, that Pepsi can show itself not to be culpable in the circumstances leading to its default, that the plaintiffs would not be prejudiced in the event that the judgment is set aside, and finally, that Pepsi would have a meritorious defense in the matter if it were adjudicated on the merits. All three of these conditions are satisfied here. First, Your Honor, Pepsi is not culpable. The facts here clearly show that while process was delivered to its agents in North Carolina, the matter was not delivered to Pepsi's legal department, that is, the party that would actually know what to do with the claim, for nearly 5 months, well beyond the 21 days typically afforded to respondents. The company cannot be found to have failed to respond to a matter of which it was not aware due to its agent's failure. Second, the plaintiffs have no plausible claim for anything else other than its loss of the judgment, which, as prior courts have held, is insufficient. As reflected in their own claim, they've waited nearly 30 years to commence action. Therefore, waiting an additional period of time to adjudicate on the merits will not cause prejudice to their case, or any other great harm for that matter. And finally, Your Honor, the defendant, PepsiCo, a large multinational corporation, can show meritorious defense if granted the opportunity. Indeed, it is readily able and eager to produce details of its internal product development materials and processes, which will allow for its defense and defeat of the plaintiff's claim. Your Honor, the parties here and the details of the case satisfy both the letter and the spirit of Rule 60B1, and as such, the judgment should be set aside. Thank you.